Good afternoon, everyone, and you're very welcome to our support webinar this afternoon on the new points-based immigration system and the EU settlement scheme and what they mean for small businesses in Northern Ireland. I'm delighted to welcome today Dan Petriello from the Home Office, who is going to cover a lot of useful information for small businesses in this particular area and topic. So just a bit about FSB. We are the largest business organisation in the UK. We have over 150,000 members across the UK and over 5,500 here in Northern Ireland. And that's across a range of different sectors and sizes. FSB offers its members a range of tangible services, such as our 24/7 legal and employment helpline, our cyber crime protection scheme, debt recovery service, a range of back office services that sometimes small businesses can't afford to employ particular personnel on. The other side of our work then is our information and events communication work, our policy and campaign work. So we rely on our members to bring to us the issues that are facing small businesses. And obviously over the last couple of years, there's been quite a number of challenges. We work as advocates for small businesses and for our members. So we will lobby and campaign those decision makers at local, regional and national level. We have policy teams covering local areas, covering the devolved nations and then working at Westminster. So really we rely on our members and small businesses to bring those issues to us so that we can give a voice. So our session today, as I said, is going to be undertaken by Dan, and I'm going to pass over to Dan, who is going to give us some really valuable information. Small businesses really need to know about these new changes, particularly in terms of where their labour is coming from, and it's really important that they get this right from the start. So Dan, I'm going to share my screen and pass it over to you.
Okay, thank you very much, Roisin. Yeah, so my name's Dan. I work on the Home Office's external engagement team, and hopefully today we're going to provide you some really key information about the new points-based immigration system, the status of EU nationals, help you signpost you to available resources, and just go through some other key changes that have happened of late. Okay, so the first thing I'm going to start with is just to go through a little bit about the EU settlement scheme and just cover some top lines really. So the EU settlement scheme, the deadline was actually the 30th of June of this year. So the EU settlement scheme is for EU, EEA and Swiss citizens who were resident in the UK by the end of the transition period, which was the 31st of December of last year. Now, the latest stats show that we've received over 6 million applications and over 5.4 million people have already received status under the scheme. Now, that status allows people to continue to work, study and access eligible services. But it's really important to note that the scheme itself is not closed and we are still receiving applications every day. In line with the Citizens' Rights Agreement, there remains scope for people who are eligible to submit a late application indefinitely, where there are reasonable grounds for those people having missed the deadline. There are also avenues for joining family members to come and join their EU national family members in the UK. So the scheme is still open. It's still processing those millions of people who are going to go from pre-settled status to settled status. So even though the deadline has passed, we are still receiving applications. Now, we publish an awful lot of information on the EU settlement scheme, more than we have for any other Home Office route. And every month we update those top level figures, and then every quarter we do a deep dive and give more detailed information, which includes things such as the age of people that have applied, where they've applied from. We break down into the different nationalities. You can see the different percentages of who got pre-settled and who got settled status. So our most recent update actually came out this week, and you can see that there have been 99,820 applications from Northern Ireland. Now, the top nationalities to have applied from Northern Ireland are Poland, Lithuania, Romania, Portugal, and Bulgaria. And also on the screen, you can see the top five places for locations of applications to the settlement scheme within Northern Ireland. Now, I've mentioned that there are when there are reasonable grounds, we will continue to accept late applications. Now, across the settlement scheme as a whole, the Home Office has taken a really flexible and pragmatic approach, and we are continuing to take that same approach when we are considering late applications. So as I mentioned previously, EU nationals have the indefinite right to submit a late application if they have reasonable grounds for doing so. And we published some guidance on what constitutes reasonable grounds, but it's really important to note that that's not exhaustive guidance. We will continue to consider each case in light of its individual circumstances. But some examples include where a parent, guardian, or local authority has failed to apply on behalf of a child. And this is something that will be may potentially be in the future. So it may be later on in life if a child realizes they haven't got the status that they expected to have when they come to start university or something like that, and it's been that their parent or carer hasn't put an application in. They will have that right to submit a late application at any point. Also, where someone lacks the physical or mental capacity to make an application, where maybe someone has been prevented from applying because they were a victim of modern slavery or domestic violence. But it's really important to note that you don't need to be a vulnerable person to make a late application. You could simply have been unaware of the requirement to apply. You may have failed to apply by the deadline because you had no access to the internet. You might not have had the actual IT skills to make an application, or perhaps English language had been a barrier to someone submitting an application. It's important to note that as soon as someone puts their application in, so even if it is late, they will have their rights protected until the outcome of that application. And in the future, we will take the same pragmatic approach to late applications. If someone has been given pre-settled status, but then fails to apply in the future for their full settled status within the period of their leave, we will again take that same flexible approach. Now, for those who haven't made an application yet, there is still a lot of support available, and that support's also available for those people who have pre-settled status or need to apply for settled status. So we have our Settlement Resolution Centre that's open 7 days a week and deals with thousands of queries every day by telephone and email. The Home Office also has funded 72 different voluntary and community sector organisations across the UK to help support those who need some extra help in making their application. Now, some of these organisations will cover specific geographical areas. Some of them will particularly focus on the particular needs of different groups of applicants. Now, the current funded network, network's funded until the 30th of September, and we've recently committed to provide further funding to that existing network that takes us through to the end of the current financial year. So that's the end of March of next year. There is also an assisted digital service. So if people just actually need some help with the actual IT side of it, there's a tiered level of support available there, which can be done over the phone or in person. Now, within Northern Ireland, there are a number of really excellent organisations that support those who are specifically in Northern Ireland. There are some organisations, as I say, that cover the whole of the UK, but these ones on the screen now are the Northern Ireland-based organisations. Now, another route just to make you aware of is on the 10th of December of last year, the government opened the Frontier Worker Permit Scheme. So protected frontier workers can apply for and be issued with a permit. So to be a frontier worker, you've got to be from the EU, Switzerland, Norway, Iceland, or Liechtenstein. You've got to live outside of the UK, so you can't be primarily resident in the UK, and you've got to be employed or self-employed in the UK on or before the 31st of December and continue to do so. Now, you can't be primarily resident in the UK, so you may be eligible if you spent less than 180 days in total in the UK over the course of the previous 12-month period. Now, applications are similar to the settlement scheme in that they're free, they're made online, and they can be made from inside or outside of the UK. But from the 1st of July, all non-Irish frontier workers have been required to hold the valid frontier worker permit in order to enter the UK for work. Now, another significant change that's happened quite recently are the changes to the right to work process. Particularly for EU nationals. It's important to note that there is no mandatory requirement for employers to do retrospective checks on EU members of staff who were employed on or before the 30th of June. Now, if in the future it turns out that someone who was recruited before the 30th of June is not eligible to apply to the settlement scheme, they haven't made an application to the settlement scheme, employers will maintain a continuous statutory excuse against a civil penalty if the initial right to work check was undertaken in line with the right to work guidance and published legislation available at the time. So anyone recruited before the 30th of June, if you'd done those checks, so you'd checked their passport or national ID card, you would maintain that continuous statutory excuse if in the future it turned out they weren't entitled to be working. Now, on the 1st of July, the process for completing right to work checks on EU, EEA and Swiss citizens changed. Employers can no longer accept EU passports or ID cards as valid proof of right to work, except for Irish nationals. An online right to work check is required for individuals who only hold digital proof of their immigration status in the UK, and this includes most EU, EEA and Swiss citizens. Now, to carry out this new form of check, you do that online, and all you need is their date of birth and their share code. And I'll go through a little bit more of what this entails now. You complete the check on gov.uk on the View Right to Work page, and also our guidance was updated on the 1st of July to include a refreshed list of acceptable documents. So this will cover scenarios where perhaps someone has applied to the settlement scheme but hasn't yet received a decision on their application. Now, the online right to work check is required for those who hold only a digital immigration status. So this is an e-visa. This will apply to most EU citizens, so those with settled or pre-settled status, but also those with one of the Hong Kong British nationals overseas visas and some other nationalities who've come to the UK more recently under the points-based system. Now, the Home Office online service works on the basis that the individual first logs into their own status, and they log into their own record, and then they share this information with you by providing their share code. The share codes are valid for 30 days, and they can be used as many times as needed within the 30 days, after which they can request a new one. The individual can give you their share code directly, or they can actually request that the share code is sent to an employer via their service. So I'll put on the screen there the email address that you'd receive a notification from, just so you can make sure that's put on your safe list and you know it's a genuine email. Now, to check the person's right to work details, you need to access the right to work checker, which you can find on gov.uk. It's called View an Applicant's Right to Work Details. And you enter the share code and you enter their date of birth. And once you've entered that information, this is an example of the type of screen that you will see when you access this service. Now, in the presence of the individual, so you can do that in person or on a live video link. you've got to check that the person on the screen here is the same person that's either in front of you virtually or in person. And when you're satisfied that that is the same person, that is effectively the check that you're doing. Now on the screen here, it will confirm that they have the right to work and any restrictions on any activity that they can do. So for instance, if you had status to work under our graduate visa, you can work in any role except as a professional sports person. And this is the kind of information that would be shown on this screen. Now you must retain evidence of the online right to work check. And you do this by the profile page that confirms the individual's right to work. Now you effectively save a copy of this page, and you have the option to print it and keep a hard copy, or you can save it as a PDF or HTML file. Now, I'd like to talk through the points-based immigration system, give you some information on the key routes. Now, we will follow this up with any of the guidance that I refer to during the session. So anything I've already mentioned or anything through the rest of the presentation, we will send out the links so you can get all the supporting materials, have access to the immigration rules and any support resources that I mentioned. So the top line is that anyone coming to the UK for work, including EU nationals, but excluding Irish nationals, need to demonstrate that they meet a specific set of requirements for which they will score points. And this is our new skilled worker route. We've made a number of changes so it's simpler for employers to attract talent, to complement the skills that we already have. And for those of you that are familiar with the previous tier 2 route for skilled work, it's certainly more flexible than that. Now, the core requirements for the skilled worker visa are that the applicant must have an offer of a job from an approved Home Office sponsor. The applicant must speak English to an acceptable standard. There's a criminality threshold for every application. And the job must be at a minimum skill level. So that is RQF level 3 or equivalent and above. So that's A level or equivalent qualification and above. That's not to say that the workers need to hold a formal qualification. It's the skill level of the job that they will be doing, which is important. Now, individuals must also meet the required salary for the job they're coming to do. And I'll go through what those salary requirements are shortly. So compared to the previous tier 2 route, what's actually different? Well, there is no cap on numbers for skilled work, so that the cap on this route has been suspended. There is no longer a resident labour market test, and that has been removed. That skills threshold has actually been expanded, and the salary threshold that I'll go through shortly has actually been lowered. Additionally, there's no longer a 12-month cooling off period or a 6-year maximum length of stay within the skilled worker route. Now, there are also tradable points for certain characteristics across some occupations, and I'll go through what this means in practice and work through a few examples with you. Now, when we say a points-based system, what do we mean by points? So for a skilled worker visa, you actually need to score 70 points in total. By meeting the mandatory criteria, so you've got a job offer from an approved Home Office sponsor, it's at the right skill level and you meet the English language requirement, you will score 50 points. Now, to qualify for that skilled worker visa, you must obtain a further 20 tradable points, and they can be for a combination of points for your salary, a job on the shortage occupation list, or a relevant qualification. Now, I've mentioned that for every occupation, there is a required salary that an individual must be paid. Now, this will either be the general salary threshold, which has come down to £25,600. It was previously over 30,000, or it will be the going rate for that job. Now, the appropriate salary for each occupation is set out in the immigration rules. It's available on gov.uk. So, for instance, a civil engineer is required to earn £35,000 because that is the going rate for that profession in the UK. And a quality assurance technician has to earn £25,600. So in that profession, the general salary threshold applies. So it will either be the going rate or the general salary threshold, whichever is higher. Now, it is possible to reduce the salary requirement if the individual can score points for their attributes or the nature of the job that they're coming to do. So if a job is on the UK shortage occupation list, you can get a 20% discount on that salary requirement. If the applicant has a PhD that's relevant to their job, that's worth a 10% discount. It rises to 20% if it's in a STEM subject. And new entrants to the labour market can also secure a 30% discount on the salary requirement. So these discounts apply to whichever sum the applicant would otherwise need to earn. So again, either the general salary threshold or the going rate for the job. And there is a general floor of £20,480, below which a salary can never drop when any discounts have been applied. There are a number of public sector occupations that are subject to separate arrangements, and they're based on published pay scales. So that their roles such as doctors and teachers. Now, we will retain the ability in the future to increase the number of attributes that you can score tradable points for to help us meet the needs of the economy, but those mandatory requirements won't become tradable. Now, we'll send out all the information on this so you can kind of go through it at your own pace, but I'm going to work through a couple of examples of how this works in practice. So in this case, the individual has come into the UK and he's been offered a job as a general manager. So they meet the mandatory requirements. So they've got a job offer from an approved Home Office sponsor. A general manager role is deemed at the right skill level. And they meet the English language requirement, so they've got 50 points. Now, the going rate for general managers in the UK is £22,700. So the general salary threshold of £25,600 applies for this role. In this case, the individual has been offered a salary of £26,300, which is above that salary threshold. So they score 20 points for their salary. So they get 50 points from meeting the mandatory requirements and then 20 points for their salary, and that gives them the 70-point total. Okay, so in this scenario, the individual has been offered a job as a butcher, and they've been offered a role at £10.40 an hour. So they meet all the mandatory criteria under the points-based system. So they've got a job from an approved Home Office sponsor. The job is at the right skill level, and they meet the English language requirement. So they score 50 points. Now, Oliver's pay per hour is above the going rate of £9.52 per hour for the occupation, but over a standard 40-hour week, that would mean the salary would be £21,632, which is below that general salary threshold of £25,600. So they wouldn't score any points for their salary, so they wouldn't be eligible for this visa. But if they were contracted instead for a guaranteed 48-hour week, the salary would rise above that threshold to £25,958, which means they would score the 20 points for their salary and would be eligible for the skilled worker visa. So it's really important when you're looking at recruitment that you really engage with the guidance and look for how the route can work and the different permutations. And we can't go through all the different permutations of it, but we will send out this guidance, and it's really useful to go through the different examples of how it works. So in this next case, the individual has come into the UK to work as a web designer. So again, they meet the mandatory requirements. So the jobs, they've got a job offer from an approved sponsor. The job's at the right skill level. They meet the English language requirements. They score those 50 points. Now, the going rate for web designers in the UK is £26,000. In this case, the individual has been offered a salary of £22,450, which is below the general salary threshold, so they don't score any points for their salary. Because web designer is on the UK shortage occupation list, though, they score 20 points for coming to fulfill a role that's on that list. So the 20 points from the shortage occupation list role plus the 50 points from the mandatory requirements gives them that 70-point total. Now, a big question at the moment for employers is whether or not they need to become a sponsor. So it's important to note that you do need to be a sponsor to bring someone in to work. Now, we've engaged and extensively listened carefully to businesses and have made a number of changes to how this sponsorship process works. So we've removed that resident labour market test, suspended the cap on numbers, and the way we actually issue certificates of sponsorship has been completely changed. It's no longer done via a monthly panel, and cumulatively this means a reduction in the process of up to 8 weeks. Now, it's really important to note that you don't need to be a sponsor to employ someone from the resident labour market. So that includes the more than 6 million EU nationals who've applied to stay under the settlement scheme. And there are other routes available that you can use that you don't need to be a sponsor for. And I'll go through those shortly as well. We also now allow migrants to switch into different routes without having to leave the UK, which they previously had to, though they obviously do need to meet the requirements of the route that they are switching into. Now, we know that this is a really important process, and it's something that we are looking to make whole-scale improvements to. We've been working with employers directly through our advisory groups, including a group specifically set up for the interests of small and medium businesses, and we are making significant changes through next year and beyond. So we actually published a paper on this quite recently, and our goal here is significant customer improvement, significant improvement for customers and the customer journey for both employers using our sponsorship system and applicants coming to apply for visas to come and work in the UK. We know that this is it's a system we've been using for a long time. So we are looking at a complete IT transformation project. So using a new system to process this work. It's going to be more intelligent. It will help us reuse information. It will help other departments speak to each other, so we don't have to keep asking for the same information from various different sources. We also want to make sure that we make significant changes to the existing processes there. We just want to make the whole process easier and remove the barriers for small businesses. But what's really important is that we engage throughout this. So we will want to speak to people who are current users of the system, who are going to be future users of the system. We want to make sure that the new system is tested with those who are going to use it to provide actual, working feedback on that. And that is, as I say, it's a long-term project, but it will be for 2022 and beyond. And we are really in listening mode for this, and we want to hear views on this. Now, as you can see, this is the current sponsorship process. So you can see why we're looking to streamline it. But if it's like now when you're thinking about becoming a sponsor, what does it actually entail? Well, your first port of call is to check that your planned vacancies are eligible under one of our licenses, and you can do this via gov.uk. If you are applying to become a sponsor, you will need to provide documentation to support your application. In most cases, it's at least 4 different documents, and these will vary dependent upon the size and nature of your organisation, but may include things like the hierarchy of your management structure, your financial accounts, your business records. And to get a license, you cannot have any unspent criminal convictions for immigration offences or certain other crimes such as fraud, and these are all explained in the guidance. Now, when you apply to become a Home Office sponsor, you'll need to appoint a person or persons within your organisation to actually manage the sponsorship process and have access to the Home Office sponsor system. You'll apply online and you'll pay the appropriate fee, which depends upon the size of your business and the roles that you're planning to fill. There are reduced fees for small businesses and charities. When you apply, we'll ask how many staff you plan to recruit through the sponsorship system over the current financial year. And if your application is successful, your license will be valid for 4 years. In terms of actually bringing in someone to work, once you've selected a candidate, they must make a visa application to work in the UK. You first endorse your prospective employee's visa via your sponsor license account, and you request and issue them with an electronic certificate of sponsorship. They can then cross-reference this as part of their own visa application. You will pay the immigration skills charge if that's required, and then the employee submits a visa application under the same category as your license. If their visa application is successful, they can then travel to the UK and start working. Now, as I previously mentioned, this is a process we are looking to streamline. So it's certainly very much watch this space with regards to this process. Now, I've mentioned that there are other routes that perhaps you don't actually need to become a sponsor to use individuals that come into the UK via those routes. So I'm going to go through some of those now. But it's really important to note that the new points-based immigration system does not seek to replicate free movement in any way. And we know that this is a significant period of adjustment for employers, with a particular focus on the resident labour market, particularly given the impact of COVID-19. Now, the new immigration system does provide some greater flexibility with those changes to the salary and skills threshold. As I've mentioned already, the millions of EU nationals who've applied to stay in the UK under the EU settlement scheme, and we hope that both the seasonal workers pilot and the youth mobility scheme will provide employers with some further flexibility. Now, one of our most recent routes is our graduate route. This actually opened on the 1st of July and represents our commitment to improving our offer to international students considering education in the UK. Now, the core principles are that the graduate needs to have successfully completed a degree or eligible professional qualification at undergraduate level or above, whilst being sponsored by a higher education provider with a good track record of compliance, and they must apply whilst they have existing leave as a student. So if you have completed a degree in the UK, you apply as a graduate and you can get 2 years leave, 3 years if you graduate with a PhD, and during this time you can work at any skill level. There are no salary thresholds on there. You can look for work, and you can then switch into one of those skilled work routes if you find a suitable role at the end of your leave period. Now, this route does not require sponsorship, so you can take any of the graduates on here, and as I say, you don't have to sponsor them. There isn't the salary and skills requirements that there are in the skilled worker route, and there's no fee for the employer. The graduates themselves will pay an application fee, and they'll pay the immigration health surcharge. And then the ambition would be that you could take someone on as a graduate, and by the end of this posting, if they wanted to remain in the UK, they would have a role that would then meet the skills and salary requirements under the skilled worker route. Now, another route that opened this year is our route for Hong Kong British nationals overseas. So this opened at the end of January, and this recognises our historic commitment to British nationals overseas in Hong Kong and gives them the option to come and live in the UK if they decide that that's an appropriate choice for them. So we've got a simple, streamlined application process. Again, there's no quota on numbers on this route. The process itself is quite similar to the settlement scheme. You can apply using the app if you have eligible documents. And set out in our impact assessment, we estimate somewhere between 250 and 320,000 British nationals overseas and their dependents coming to the UK over the next 5 years. And again, those with a Hong Kong British nationals overseas visa do not require sponsorship to work in the UK. So they can come to the UK and their family members, and they can work in any profession at any skill level. Now, visitors, so anyone can apply to visit the UK. It's important to note that citizens of the EU and Switzerland do not require visas to come and visit the UK. In most cases, you can visit the UK for up to 6 months, and that can include multiple entries, but you can't live in the UK by means of repeat visits, and you can't routinely work or access public funds. We will, however, permit study of up to 6 months under the standard visit route. Now, we know that there's a huge change, and although our visitor rules haven't necessarily changed, there are large groups of people who are having to interpret them who haven't had to before. So what we really recommend is that employers have a look at our visitor rules and see which kind of activities you can still do under the standard visit route. So what we don't want is people unnecessarily applying for visas when they don't need them, and equally people coming to do activities when really they should have a visa to do that. So if you are coming for work purposes, you can do things like attend meetings and conferences. You can come and negotiate contracts. If you're an academic, you can come and take part in research. There are various activities there, and we will send the link out on here. And I just really recommend that people have a look at this and understand the permitted activities that do and don't require a visa. And we have just published, and we'll send this out as well, it's like a mobility guide for aimed at like business travel, so you can see the different activities that are permitted. Now, we've produced a whole suite of resources to support these changes. So we've got a lot of EU-facing materials. So we've got stuff for EU workers, students, visitors. We've also got our introductory guide to employers. We've got a guide to the Frontier Worker Permit. We've actually done some work with the Association of Labour Providers and worked together with them on their handbook. And there is also a podcast that you can download for free and listen to, and it goes through these kind of issues in a bit more detail. We've also got that guide to sponsorship that I briefly mentioned before. And there's also a leaflet that helps EU nationals understand whether they're eligible to apply to the settlement scheme or whether they should have a status under the new immigration system. So there's a lot of materials there available. That's the end of our presentation here, but we will send out all the links to all the different materials because there is a lot of support available.
Thank you very much, everyone, for joining this afternoon, and thanks to Dan and Hannah and the rest of the team at the Home Office for putting this session together. Obviously, there's a lot of information there and a lot to take in, and we would urge our members and small businesses to try and ensure that they are aware of the guidelines and aware of the information and the support before they start into any process, because it'll be much easier when you're armed with that information and doing the thing right in the first place without then having to work backwards. So look, a lot of information there. It's always changing as well. So we will try and keep you as up to date as possible and perhaps do another session at the start of next year on this particular subject. But take a look at all the links within the presentation, and always be in touch with us if you have any particular queries, and we'll see if we can get you an answer. So thanks for joining us today, and do come along to future events with FSB Northern Ireland. Thank you.